My name is Jeff Morgan. I'm from Dallas, Texas. As many of you may know already, the Attorney General for the state of Texas, Ken Paxton, filed a letter brief amicus curiae on behalf of Jeffrey Younger, and this is in regard to Jeff Younger, number 221137, in which the state of Texas, by and through Attorney General Ken Paxton, submits this letter brief as amicus curiae in the above matter. In the state's view, the petition for this relief should be granted, and Mr. Younger was actually asking for an emergency stay and also a writ of mandamus, and any appropriate administrative or emergency relief should immediately issue to preserve this court's ability to review relatives' claims in an orderly fashion. So after I read through the letter brief that was submitted on behalf of Mr. Younger, I decided to write my own. Now, I will tell you the first thing is I did not file it correctly. I did not really know what I was doing. I basically took a look at what Mr. Stone had actually submitted, and I tried to more or less copy it. And then some people gave me some advice on what I should do in the future, how I should e-file it and everything else. And you know, from my perspective, not getting it exactly right is not really a big deal. If we're not willing to do something wrong to learn how to do it right, we'll never do anything. But I did decide to read my letter that I did send to Jed S. Stone II, and then also there was another person that I sent it to as well. So I'm going to do that right now because I think that there's another issue here that was involved in this whole matter, this case that was heard on September the 1st, 2022, because Mary Brown closed the court to the public. And this is a constitutional issue of such grave importance that due to her closing the court to the public, actually the whole decision should be reversed. There should be a mandated reversal. So this was what I wrote. This completely, this is just my thoughts on the whole thing. Again, I don't think I filed it correctly. In fact, I know I didn't file it correctly. And I don't know if there's another way that I can still do it correctly or not. But at this point, like I said, I just wanted to make sure that my name somewhere was on the record. So what I wrote was this. December 22nd, 2022, Jed S. Stone II, Solicitor General, regarding number 221137 in regard to Jeff Younger. Dear Mr. Stone, I would like to supplement the state of Texas letter brief as amicus curiae in the above matter. In addition to the petition for emergency relief being granted and any appropriate administrative or emergency relief, the actions of Judge Mary Brown to deny public its reasonable right to access the court proceedings in the above-mentioned matter mandate a reversal and a new trial. Because she closed the courts to the public, the court proceedings to the public, the entirety of the court proceedings were closed to the public, a reversal is mandated and a new trial is mandated. According to the background and legal standards, public right to access remote hearings during COVID-19 pandemic, primarily authored by District Judge Roy Ferguson of the 394th District Court and issued by the Office of the Court Administration, courts must ensure and accommodate public attendance at court hearings. The court has the affirmative burden to ensure meaningful and unfettered access to court proceedings, and the court must take all reasonable measures to ensure public access. This is a constitutional right that belongs to the public and cannot be waived by the parties. I know that Mr. Younger was not waiving his right to this. The public wanted this. Now maybe Ms. Georgelis wanted to have the whole meeting sealed off to the public, and maybe her attorney Jessica Janicek wanted to have the whole proceeding sealed off to the public, and maybe Judge Mary Brown wanted to have the whole proceeding sealed off to the public, but they're not allowed to do that. This is a constitutional matter. The right of public access belongs to the people. We, the people of Texas, have the right to monitor our courts, to observe the operation of our courts. There is the open court doctrine in our Texas Constitution. It says the courts shall remain open. And according to Judge Roy Ferguson of the 394th District Court, this is a very big deal, and that if a judge closes the proceedings, the court proceedings, a reversal may be mandated and a new trial may be in order. Again, this is a constitutional right that belongs to the public and cannot be waived by the parties. Lack of access to a single hearing, suppression, or even a portion of a single hearing, voir dire, is enough to mandate reversal and a new trial. When the court chooses not to provide reasonable and meaningful public access to remote court proceedings, it may equate to constitutional error and mandate reversal. On September the 1st, 2022, Judge Mary Brown closed the remote hearing to the public. I know because I and many others who were wanting to observe this hearing were not permitted to have access to the courts. We were intentionally denied. And I think one of her administrators or something like that actually sent out conflicting messages. 3 messages, I believe, that when we called or when we emailed or whatever we did, we got different messages. So she was lying about it as well. And as I continue on here, I and numerous others were forbidden from observing the operation of the 301st District Court in the matter pertaining to Jeff Younger and Ann Georgilis. Judge Mary Brown not only closed the courtroom to the public, but I and others were given contradictory and lying messages as to why the hearing was closed. We were told that the hearing was being done in person. It was not being done in person. It was a remote hearing. That was a blatant lie. There were a couple of other reasons we were given as well. To continue on, once again, closing the courtroom and then lying about it was unwarranted, inexcusable, and constitutionally suspect. I provide additional public testimony on the matter on my YouTube channel and I gave the link to where my video is, pertaining to what Mary Brown did in this situation between Mr. Jeff Younger and Miss Ann Georgilis. Not only do I believe that a reversal is mandated, but I believe that Mary Brown should be disciplined for intentionally depriving the public access to the hearing and then lying about it. And yes, I am saying that she lied about it. Respectfully, Jeffrey S. Morgan. So this is a case right now that's being challenged publicly. Once again, the Attorney General, the state of Texas, through the Attorney General's office, is stating that an emergency stay should be done, and also that the relief that Mr. Younger sought should be granted. And I would add, the entire thing should be reversed because of constitutional error, because Judge Mary Brown intentionally, willfully denied public access, the ability to monitor their courts, to see what was going on in her courtroom. And I believe that was done with the intent of depriving the public so that they would not criticize her for what she did in the matter of Jeff Younger versus Ann Georgilis. This is abusive, and Jessica Janicek, the attorney for Coons Fuller, I would think that possibly she may have suggested that the hearing be closed, but I don't have any record of that if she did. But I believe that Attorney Jessica Janicek should have reported this willful violation of Mary Brown to the State Commission on Judicial Conduct. She had a duty to report. She failed in her duty to report. So Jessica Janicek, too, should also be investigated, rebuked, reproved, disciplined for her failure to report. She had a duty to report, not a duty to lie, not a duty to cover up, not a duty to muddy the issues, but a duty to report. Judge Mary Brown. I know in other cases that I've been to, and I've been to many cases over the last couple of years, there have been times when the attorneys have told the judge, you can't do this. Judge, that's not what the Texas Family Code said. Jessica Janicek, who prides herself on being this wonderful attorney, knew that the courts should not have been closed to the public. I believe that Jessica Janicek of Coons Fuller Law Firm failed in her duty to report. I believe she too should be investigated, and whatever appropriate actions are necessary should be taken against her, in addition to the actions taken against Mary Brown. And I also believe that a reversal of the decision done in this entire proceeding is mandated because of the constitutionally suspect nature of what took place willfully by Judge Mary Brown. Thank you.